Hey guys, and welcome to today's video. Today we have a pro se sovereign citizen with a law degree from Google University who insists on representing himself and a judge who is not going to have any of that sovereign citizen nonsense in his courtroom. So let's begin.
Lincoln County Municipal Court is reconvened.
Please be seated. All right, we are on the record in case number 25 TRD 01258, caption the State of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Miss Yeager is here on behalf of the State of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under a OVI suspension, and the other is driving under a it looks like it says security on the citation, but according to the new Albany Municipal Code, it's basically just driving under a forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to a $1,000 fine, and up to a 1-year license suspension. Does carry mandatory minimum penalties of up to, or of at least $250 fine, a 1-day license suspension, and at least 3 consecutive days in Lincoln County Jail. The other charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be one conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have documents, if I could serve the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been tossed up from the clerk, and as well, my case is in fact on an appeal at the moment.
On appeal where?
I'm sorry.
On appeal where?
It's an appeal.
In what court? Is what I'm saying. Where have you filed an appeal?
The Court of Appeals,
Okay, which district?
the 10th District.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th District. You're absolutely right. It's the 5th District. I have
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court. That's what it looks like.
that one, or this.
But just in general, all of your filings with this court are on this. It's kind of a unique.
Font.
The documents are unique in that they're gray and they're typed in all caps, and one of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division, and this is obviously Newark, Ohio.
Well, that's awkward. First step in representing yourself is know what state you're in, because filing your frivolous paperwork in Newark, New Jersey when your case is in Newark, Ohio is the same thing as doing nothing but with extra steps.
By jury, but in order, in a what we call a petty offense, and a petty offense is anything punishable by less than 1 year in prison. A jury trial is not automatic. It has to be demanded, and Rule 23 of the Ohio Rules of Criminal Procedure require that jury demand be made not less than 10 days before the scheduled bench trial. So your request for a jury trial would be untimely. Now, I'll entertain a position from the state in that regard. Do you intend to represent yourself throughout, whether you have a bench trial or a jury trial? Or did you want the court to, or are you going to ask the court to appoint an attorney to represent you?
Represent myself, Your Honor.
Okay. Well, I'm going to go ahead and I'm going to deny what I construe to be a motion to continue for the purpose of setting the matter for a jury trial, because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the the motion was made, but that the court denied that. Your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to change your pleas from not guilty to guilty or no contest?
Your Honor, if it pleases the court, I motion that this case be continued and or stayed because the case is now on an appeal in the 5th District Court of Appeals. Also, the case has been petitioned removed to the Ohio District Court under case 223 CV 02962 JLG CHG and to the New Jersey District Court under case 224 CV 03934 LEFJBC. The court's jurisdiction is divested until those courts determine otherwise.
Well, actually, none of that is true.
I guess he didn't hear you when you said that this was Ohio and not New Jersey. And I think everyone can appreciate a judge who doesn't allow this sovereign citizen to thrive in his courtroom and has no problem telling a crane eater that they have no idea what they are talking about.
Basically, number one, your paperwork from that purports to be from the federal district court doesn't look like pleadings from the federal district court. Those are plain white paper with the case number in blue up at the top of the page, and that's not how yours are captioned. Furthermore, as far as jurisdiction is concerned, this court does have jurisdiction because this is an alleged violation of the traffic laws of the city of New Albany that is alleged to have occurred within Licking County. This court has jurisdiction over traffic offenses that are alleged to have occurred within Licking County. And by being here today and by entering pleas, you've waived any objection to personal jurisdiction over you. All right?
Your Honor, I object on this bench trial. I do want a jury trial.
Okay, and as I've already explained to you, you did not make your demand in a timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me like you don't want to, I know you don't want to change your pleas from not guilty to guilty or no contest, so at this time I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Kors to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat, but Mr. Mackey, you indicated that you do wish to represent yourself, correct? Is that right? Okay. So you have the right to be represented by an attorney by hiring one of your choosing. You're also eligible to ask the court to appoint an attorney to represent you at no cost. If you qualified based upon your income, your expenses, your household size, the court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to counsel. 1258. So I'm going to have the bailiff hand to you a form entitled Attorney Waiver. I'm just going to read it into the record in open court for right now. It says, it's captioned Attorney Waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So if it is your intention to represent yourself and to waive your right to account to an attorney, go ahead and sign by the X there, but do please read that because I'm going to make sure that you understand what it is.
Yes, that
I've been objected to this. I object this trial.
I'm sorry, I didn't hear what you said.
Refusing to sign this, Your Honor. At this moment, I'm not refusing to sign it. This court jurisdiction has been divested.
Claiming that the court's jurisdiction has been divested or that the courts don't even have jurisdiction to begin with isn't one of those things that become true if you say it enough times. Has already ruled on that poorly proposed motion and denied it. Now, a police officer is about to take the stand and I'm going to cut out all of the technical testimony and leave in just the pertinent parts.
Okay, well, I've already ruled on that, and that can certainly be appealed at a later time. But this part of the case, this portion or this part of the process is going to go forward. If you later appeal, if you're found guilty, I'm not saying you will be, but if there's a conviction that's entered, you have the right to appeal to the 5th District, arguing that this court never had jurisdiction over you, which means basically this would all not count. But you don't get to make. I've already made the determination that the court does have jurisdiction over you. If you don't want to sign that form, obviously I can't make you do that. But I will declare what's called a constructive waiver of counsel. And what that means is you've said out loud that you wish to waive your right to counsel, that you want to represent yourself. I'm going to accept that as a valid waiver of counsel, even if you don't wish to sign that. So, Ms. Kyle, if you'll bring this back to me. And for what it's worth, Mr. Mackey, this was filed with the court, and I do have a copy of that, and I did look at it, okay? All right, very well. Please swear in the witness.
Do you solemnly swear or do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I affirm.
Please have a seat, sir. For the record, you're gonna give your name and spell your last name.
Officer Michael Coors, Cohrs.
And the address of your precinct?
50 Village Hall Road, New Albany, Ohio, 43054.
Thank you, sir.
Thank you. You may inquire.
Officer Force, how long have you been with the New Albany Police Department?
Over 6 years.
And were you so employed on January 29th of 2025?
Yes.
And were you working that day?
Yes.
What shift or hours were you working?
Second shift, it's 2 p.m. to 10 p.m.
And were you wearing a uniform of the day like you are in court?
Yes.
And were you driving a marked cruiser with a working visible light bar?
Yes.
And what were your duties that day?
I was working standard patrol. I would believe I was on zone 3, which is the Licking County side of New Albany.
Is that for like traffic enforcement?
Correct.
And what kind of training have you undergone for traffic enforcement?
I was trained at the Columbus Police Academy over 2 weeks of traffic enforcement to include all traffic laws and proper traffic stops and procedures.
And as of January 29th of 2025, were you up to date on all continuing education, training, and certification requirements?
Yes.
I'm going to draw your attention to about 4:50 p.m. Whereabouts were you on patrol at that time?
I was on Beach Road heading southbound just north of State Route 161.
And is that in the city of New Albany in Licking County, Ohio?
Yes.
And while on patrol, what first drew your attention to the defendant's vehicle?
As he was traveling northbound, making a left turn onto the State Route 161 westbound on-ramp, I observed he had dark tinted windows, which initially drew my attention. And then as he passed me, I made the right-hand turn, drove behind him, and entered his license plate.
Okay. And did his license plate, when you ran that, return anything?
It did. It turned through my mobile computer, through our leads program on there. I observed that his license plate had expired, or registration, I should say, expired on July 8th of 2024.
And so when you approached the defendant for the stop, did you inform him as to the reason for your traffic stop?
I did.
And did he have anything to say about that?
He stated he was aware that the registration had been expired.
Okay. And did he have a driver's license for you too?
He had an identification card.
An ID card? Okay. Were you able to then go back to your mobile unit and run his driver's license status?
Yes.
And what did that return?
I observed, again, through my computer system, that it showed he had multiple active suspensions, one of them being the OVI suspension that he was cited with, as well as the 2 non-compliance suspensions. On my system, reason why it was shown on the citation as a security suspension, that was the label, but per what I read through the system there, it was the financial liability.
Nothing further for this witness at this time, Your Honor.
All right. So, Mr. Mackey, you have the right to ask this question witnesses. You have the right to ask this witness questions if you wish, but you're not required to. And once the state's rested its case, you'll have the right to present evidence on your own behalf. But this portion of the trial is just for questioning. Do you have any questions for the officer?
No, Your Honor.
I'm gonna continue to laugh at these pro se dumb who insist on representing themselves in court only to not actually do any representing when it comes to trial. By doing this, you are saying to the court that you have no issues with the credibility of the witness or their testimony. But hey, he's his own lawyer, and who am I to question his legal strategy, no matter how inept it is?
Lessen the state's burden of proof. It doesn't diminish your presumption of innocence. But you do have a right to present evidence by calling other witnesses, introducing exhibits into the record, and testifying on your own behalf. If you elect to take the witness stand, however, you will be required to either swear or affirm to tell the truth, in giving me your side of the story. And when you're finished giving your side, you will be required to answer any questions that the prosecutor might have. So other than yourself, do you have any witnesses that you'd like to call today?
No, Your Honor.
Okay. And do you wish to testify on your own behalf?
Your Honor, I object from this bench trial. Respectfully, Your Honor.
Okay. And I've entertained that objection on more than one occasion now, and I've already overruled it, so it's not necessary to do that. But you are creating a record here, Mr. Mackey, so that, we're recording all this. You'll certainly have the right to obtain a transcript of the proceedings and pursue your appeals regarding the jurisdiction issue. But again, my question that I'll ask one last time is, do you wish to testify on your own behalf?
No, I'm fine.
No, no, you're not. You're because not only did you not challenge the witness's testimony, but you didn't even give any yourself. There's almost no way that a lawyer could have done worse for you than you doing nothing at all. So now it's time for the judge to make his ruling and deliver the sentence.
Okay, very well. Well, the court's heard testimony from Officer Coors, which finds to be credible, that he was on duty on the date in question, that he executed a traffic stop upon discovering that the registration on the vehicle was expired, that he made contact with the driver, who he's identified as the defendant, and upon reviewing the information provided by the Bureau of Motor Vehicles, determined that he was under both an OVI suspension as well as a Financial Responsibility Act suspension. The court furthermore has admitted into evidence over the defendant's objection, admittedly, a certified copy of the defendant's driving record through the Bureau of Motor Vehicles, and it does in fact list both the noncompliance suspension as well as the OVI suspension, and reflects the expiration date of the registration as being prior to the date of the traffic stop. So I do find that the state has met its burden on all three counts, and I'll go ahead and enter guilty findings. You have the right to make a statement today, Mr. Mackey, before I make any decisions regarding your sentence, but you're not required to. Is there anything that you would like to say other than the jurisdictional issue?
No, Your Honor.
All right, thank you, Mr. Mackey. Ms. Yeager, did the state wish to be heard regarding the matter of sentencing, and which driving under suspension charge did the state wish to elect to have the court enter a conviction and sentence?
We would elect to undergo the OVI suspension, Your Honor. And the defendant does have minimal history, so we would just recommend the mandatory minimums on that.
All right. It's kind of customary for me to ask questions of the defendants about their personal circumstances. If you don't want to answer, that's fine. Do you work? Do you have a job?
Yes, Your Honor.
What kind of work do you do?
HVAC, sheet metal, as I told the officer that pulled me over.
Is that what you were doing that day? You were working out at the warehouses? Okay. Do you work for yourself? Do you work for yourself or do you work for a company?
I work for a company.
Okay. How long have you worked for them?
It's been 3 years. I've been in a skilled trade.
Okay. Well, here's the thing. One of the reasons why I'm asking you these questions today is, as I mentioned earlier at the beginning of our proceedings, the court is required to impose at the very least a 3-day jail term. I don't want to cost you your job. Do you work Monday through Friday?
Saturday, Your Honor.
Monday through Saturday? Okay. We normally do not have, well, let me go ahead and pronounce the sentence first, and then we'll talk about that. When you got pulled over that day, Mr. Mackey, you were just given your citation and then you were free to go, right? They didn't take you to jail, did they?
Correct.
Okay. All right. As far as the registration is concerned, the fine on that charge is going to be a $25 fine. On the driving under the OVI suspension charge, the court's going to impose a 3-day jail term, a $250 fine, and a 1-day license suspension to be start today and as of midnight. Costs will be assessed. Now, the reason I was asking you about your work and everything else is, as I said, I don't want to cost you your job, Mr. Mackey, but I don't have any discretion when it comes to those 3 days in jail. Normally, we require defendants, I'm assuming you don't want to go today, right? No. Okay. So it's customary for the court to grant what we call report dates. Some courts call them enforcement dates. And typically, we require that the defendant report here to the courtroom. But since my colleague, Judge George, took the bench, we now have the option of having folks report directly to the jail. And that's important for one reason. If you had to report here, you'd have to report on a day that the court's open, so Monday through a Friday, all days of which you work. But if I order that you report to the jail on a Sunday, at least one of those days, you won't, of the 3 days, you won't be missing work, okay? Would you like for me to grant you a report date to the jail on a Sunday? I mean, I know you don't want me to impose any jail at all, but under the circumstances, would you prefer that I make it so that you report to the jail on a Sunday so you only miss 2 days of work? Okay. All right. Let's set it out a little bit just to give you some an opportunity to make those arrangements with your work. Let's go ahead and I'm going to have you report directly to the jail on Sunday, May the 4th. And that's located at 155 East Main Street here in Newark. And the bailiff will give you all the information that you need. I said, what did I say, the 4th?
Yes.
Yes.
Okay. And that's going to be at 11 a.m., Mr. Mackey. And then you'll get out 3 days later. Now,
What a tyrant. Not because he sentenced him to a mandatory 3 days in jail due to his multiple previous OVI convictions, but because he set it up in a way that he could do his jail time without losing his job. I'm sorry, I didn't mean tyrant. I meant badass. All right, so before we get out of here, the judge had some final harsh words for this soft idiot.
can I speak bluntly to you? So, you're not the first person who's come through court with these arguments that you're making regarding jurisdiction and the right to travel and things of that nature. I don't know whether you genuinely and sincerely believe that that's the law. I'm here to tell you that it's not. But even if you do, I got to tell you, a lot of times folks who espouse these arguments just continue to find themselves in court and they don't win against the system. It may be unfair in your mind. I get that. I understand. But I just want to give you a word of caution that, you know, if you do get cited in the future with any traffic violations or even criminal offenses, making these arguments is not going to work out in your favor. It's not going to help your situation. You know, you can be as frustrated and angry at the system as you want. The law is what the law is, but I would just recommend that in the future, you know, just deal with it regularly and move on. You know, the only thing that you need to do is, you know, comply with the driver's license laws, and you won't have to worry about having to listen to guys like me anymore. Okay?
Well said, Judge. You know what amazes me is that these anti-government-ass clowns could spend just a couple of dollars a year to stay off the government's radar and out of the court system. Instead, they choose to be sovereign citizens, which ultimately puts more money in the government's pockets, and they end up spending more of their lives in government facilities. So, if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.